1 2 1 2 test test 1 2 3.
Good morning, ladies and gentlemen. Our first case for argument is United States against Battio. Mr. Lemma.
Good morning, Your Honors, and may it please the Court. My name is Matthew Lembo of Perkins Coie, and I'm representing Jeffrey Battio in this appeal. Now, I'd like to reserve 5 minutes of time for reply before diving into my argument. This case is about whether the government can pursue criminal penalties for business decisions with which prosecutors, in their discretion, disagree, sweeping away the safeguards provided to corporate executives in the civil context. Here, the government prosecuted an ambitious entrepreneur engaged in over a decade of product development, hoping to launch the next revolutionary technology product. He raised money from investors, as nearly all entrepreneurs must do, and spent much of it paying employees and contractors, renting facilities, building prototypes, and taking a small salary for himself. When he was unable to get his products into the hands of the masses, disgruntled investors got the government to act on their behalf. At best, this should have been a civil dispute between the investors and a chief executive of a company, not a case that warrants the government spending public personnel, time, and money to prosecute. Here, there is no—
Sounds like a speech you make to the prosecutor before the prosecution decision. But we're here after a jury verdict. Time is short. You might want to address the legal issues that pertain after the jury is convicted and the district judge had said there was plenty of evidence.
Yes, Your Honor. Well, here, there is no well-defined scheme, and that is one of the requirements of the mail and wire fraud statutes.
I'm not sure that that's true, though. I mean, I would like you to explain to me why Mr. Battio's repeated statements that product was, quote, ready to ship were not false and misleading statements. He said this. In my lay understanding of ready to ship doesn't mean sometime in the next decade. It means ready, like in the next month or so. He would take orders. He would promise to personalize things. How is that not just an out-and-out misrepresentation?
Your Honor, I believe there is disagreement on whether he was taking orders for products. I believe you may be referring to
We have to take the evidence in the light most favorable to the jury verdict. So you should address Judge Wood's question as posed.
Yes, Your Honor. There were no orders for sales. I believe Your Honor is referring to the Indiegogo fundraising campaign where he solicited contributions for perks or rewards. Those sites are crowdfunding organizations.
But in 2016, as I read the record, you can tell me it's not there, but I think it is, he allows pre-orders on this Indiegogo site. He posts an update saying shipping is expected to begin the first week of August 2016. He posts misleading videos of his wife holding a so-called prototype, which is nothing of the sort. Just for one example, I mean, there are many, many examples in the record, but how about that one?
Well, Your Honor, I think that falls to the burden of the government to show at the time he made those statements he didn't genuinely believe.
Well, that's what the jury concluded under the instructions he was given.
That is, Your Honor. And as for the video that's referenced, the updates provided around the time that that video was posted revealed that it could not possibly be a demonstration of a final completed product. For instance, in
So what
March—
does he mean when he says to his contributors, you can see the working prototype in action?
Yes, Your Honor, that was a product demonstration video in which he was showing features being demonstrated once the ultimate product was completed. And in fact, in some of the updates that accompanied those videos, he informed contributors that in March 2016, for instance, he has been working on a pre-production prototype, meaning that a final prototype had not even been completed at that time.
It sounds like you're asking us to reweigh the evidence, which post-verdict, getting over the hurdle of a sufficiency of the evidence is not asking us to reweigh it.
Your Honor, we are not asking for this court to reweigh the evidence. We are pointing to additional facts that the government did not want to discuss in detail at trial that show there should have been a reasonable doubt.
How do you get around the Sony statements when your client told investors that his company was currently in discussions with Sony Electronics on partnering licensing the products, and the executive from Sony testified that he never discussed Sony licensing with your clients?
There is a dispute as to the Sony licensing elements, and the government had failed to show at trial that Mr. Badio did not genuinely believe he was in licensing discussions with Sony at that time.
He made a representation. There is evidence in the record that he affirmatively made this representation to some of his investors, and the evidence from Mr. Martin, Sony's employee, was crystal clear. I've never had those discussions. How do you get around that post-verdict?
Well, I think it turns on whether Mr. Badio thought that he was having discussions with Sony regarding
Was there
licensing.
evidence that he was insane?
No.
How else do you think you're having discussions when there are no discussions?
Well, he did have a discussion with the CIO of Sony. They had 2 Radian prototypes deployed at Sony's offices.
But that's not licensing. He had a discussion where he was hopeful, but his misrepresentation was specifically about partnering and licensing.
And I think that falls on the government to show how Mr. Badio construed those representations from
No, but the
Sony's.
jury can infer from all of this evidence. Usually people don't, have some device that you can shine in their brain and you find out what they're thinking. We have the Sony executive saying nothing of the sort. Maybe I told him he could put a couple of things in the office. That's a far cry from licensing discussions with a major company like Sony.
Yes, Your Honor. But again, I would return to, it was the government's burden to show how...
And they did. The jury was persuaded. I mean, again, I think Judge St. Eve is exactly right. We are not here to be the jury.
If this
maybe
court...
we should talk about something else.
Yes, Your Honor. And one thing I would like to highlight about this points to one of the fundamental issues with the government's case below. They alleged a 13-year scheme starting from 2003 and extending through 2016, and said this was the entirety of Mr. Badio's operations in this time was one large ploy to defraud investors. The government went all in on this contention. And this was an unforced error. The government could have alleged multiple schemes or smaller schemes, but what it said was it was one, and that's what it had to prove at trial. And in U.S. v. Camille, coming out of the Third Circuit, that court found that an acquittal is warranted when the government defines the scope of its scheme broadly and then fails to prove it at trial.
But here's the problem with this. Again, could a jury have rejected the idea of one scheme? Perhaps yes. I mean, but that's not the question. These various companies that he used were tightly related to one another. He was doing the same thing. This whole thing, which, to be quite honest, does not strike me as such an amazing idea, that you could have, a laptop and a tablet and a phone all docked in the same thing, so they were somehow interactive. Just doesn't strike me. But anyway, that's not the question. He is doing the same thing with these products from start to finish, or there's evidence that a jury could credit that he is. So I don't see where there is such a failure of proof that you've met the standard for setting aside a verdict.
Well, I'd like to turn to the 2003 to 2007 timeframe in particular as an example of where the government's evidence falls short. To show the start of the scheme, the government points to a 2003 private offering memorandum, which I'll refer to as a POM, that Armada had released.
Please
don't.
Please use real words.
Yes, Your Honor. I will refer to it as a private offering memorandum.
Fine, thank you.
That Armada had released to potential investors. Now, this is a legal document that not even the government alleged Mr. Badio had drafted himself, but they focus on a single line in that private offering memorandum that said the first product Armada intended to ship or to pursue, I should say, was the Phantom, was that it was, quote, virtually complete from a design perspective.
And approaching market readiness,
Yes, Your Honor.
which it was not, because by 2006, maybe at most they had a proof of concept prototype, but it had failed safety testing. It was not approaching market readiness.
Well, Your Honor, that was Armada's second product, the Radian. The 2003 private offering memorandum referred to the Phantom, which was intended to be an updated version of the Voyager product that Mr. Badio had spent years developing at Zentex, which the government does not allege was part of the fraud. So according to the government's theory in this case, at the formation of Armada in 2003, he had already devised of a massive scheme to defraud investors, rendering the entirety of his pursuits at Armada and beyond null. It was a road to nowhere.
So what? But it's all it's not like he's, you know, in the goat milk business one day and the next day he's in the computer business. He is continuing with this story, I guess I'll say. What about late 2008? He tells investors that he's, quote, actually beginning the process of building and shipping the first Radians, whereas in fact, at that time, he had stopped paying rent for this gigantic warehouse that he had located, and he didn't have any employees.
That, Your Honor, was because, and I don't believe this fact was disputed at trial, he had run out of money at that time, but...
But he's still making representations that it's ready to go. Even though he's run out of money, he can't continue to pay the engineer.
And in those statements where he was saying it was ready to go, he had made clear to potential investors that additional funds would be necessary to carry it.
But it wasn't ready to go. That's the problem. If he had said, oh, I'm out of money, it's not ready to go, I need more to get it ready to go, that would be a different story. But that's not what he said. He repeatedly told them over and over, it's approaching market readiness. I'm ready to take pre-orders. That's a very different scenario than you are asking us to look at this evidence as.
Yes, Your Honor, and that's why if this court were to find some basis to affirm a jury's finding of a scheme, the issue still fundamentally resolves down to whether the government proved the entire scope. It is the government's burden to show when Mr. Badio developed any potential scheme to defraud investors. They say it began in 2003, but the evidence does not support that. No reasonable juror could have found beyond a reasonable doubt.
Mr. Lembo, I'm going to repeat what Judge Easterbrook started out with. You may have stronger arguments than sufficiency of the evidence here. That's an uphill battle, no matter what the case is, but I think you may have better arguments here.
I would like you, for example, to address your argument about the calculation of the loss and the calculation of the restitution.
Yes, Your Honor. There are a few points on loss amount and restitution. This ties a bit into sufficiency of the evidence because if the government failed to prove the scheme started in 2003 but started at some point later, most of the funds that were raised were from the 2004 to 2007 timeframe, which would cut...
Can you show me why any of this money, let's take the number that that the district court used, which was approximately $5.7 million for loss amount, turned out to be a little bit less for restitution, more in the $5 million range. So did anybody get any benefit whatsoever from this money?
They got the value of Mr. Badio's services, and the one thing I would like to stress...
What's the value of his service at this point? Isn't it zero?
It is trying to bring a product to market. This was a high-risk investment that the investors understood when they made their investments, and if loss amount can be calculated as every dollar investors contribute to a project that ultimately fails, then any entrepreneur will be liable for the entirety of their pursuits.
If they're defrauding people, yeah. But not everybody defrauds people and tells them that something is ready when it isn't.
Yes, Your Honor. Our position would be that the government had failed to prove the entirety of the scheme, so a significant portion of that loss should not be attributable to any fraud that this court might find for affirmance.
But this isn't as though, suppose counterfactually, he had sold, 1,000 units, promising that they would have all sorts of fabulous performance characteristics. And in fact, they were just, no better than, a low-end Chromebook that you could buy, anywhere around. So in that instance, you would offset the value that you actually got from the product as against the amount that people paid, thinking, believing the fraudulent statements. But in this case, they got nothing. They just sent their money off into the stratosphere and away it went. So why isn't that both the loss amount and, in this instance, the restitution amount?
Because there were genuine investments in attempts at product development.
What case do you have that says that valueless, and from the point of view of the funds contributor, investments that prove to have no value? You're making a big social argument that yes, we like innovation in our society. We're all well aware that many innovative efforts don't come to fruition. That's the nature of things. The pharmaceutical companies would be happy to tell you most drugs fail, lots of things like that. But we're at a different stage of the process now. We're saying you defrauded people, and now we need to compute sort of what sentencing criteria should be used and also how much money you have to pay back.
Yes, Your Honor, and our position would be that genuine product development for efforts that failed should not be included in that loss amount.
But who says that? I mean,
I would have to find the particular case, Your Honor.
Well, maybe there is a case. I don't know where it is.
Yeah, yes, Your Honor. I would have to look that up for you separately. I don't have it.
Why wouldn't you have briefed it, though? Isn't that central to your argument?
Well, I think this is one of the issues that may not have been addressed by courts previously about whether entrepreneurial endeavors, how to calculate loss.
How can that be when there's a scheme to defraud? When he's convicted of a scheme to defraud and there's no product that was ever developed that's sold?
Yes, Your Honor. Most entrepreneurial endeavors do not succeed in an ultimate product. And if the government can point to what it classifies as misrepresentations after the fact, that would expose entrepreneurs to liability.
Not if they're honest about what they're doing. I mean, you can read the Wall Street Journal every day. You find out, that people are experimenting with different kinds of, solar panels, or they tell you what they're working on, but they don't have to lie about it. They decide what they're going to disclose to the public, and they do.
Yes, Your Honor. I would like to reserve the rest of my time for reply.
Certainly, counsel. Ms. Greenwald.
Good morning, Your Honors. I think I'll start with the loss. Our position on loss and restitution is that it was waived. This is a clear case of waiver. With loss, the court asked 3 times whether he had any objections, and the only one raised was criminal history.
On the loss amount, he did file written objections in advance.
He did.
The restitution is separate because
Yes.
there was not an objection to that, and
Correct.
I think there was a strategic choice at sentencing with
Correct.
regarding that. But on the loss amount, why wouldn't it be forfeiture rather than waiver? Because he did submit written objections in advance, and we have some case law suggesting that is sufficient to at least make it a forfeiture issue.
Agreed, Your Honor, except that here what happens is, in addition to at sentencing being asked 3 times and referring to criminal history alone, it's also clear there was a strategic decision made here. Because what happens is the main argument he had on this loss figure was that braver evidence that had no foundation. And
that's the evidence where he just told the man the numbers to be
Exactly.
put in, and that the QuickBooks had been
Exactly,
tampered.
and Braver, when he did testify, said he didn't even know who prepared, couldn't remember who even prepared these QuickBooks that could be altered. But the bottom line is at page 38 and 30, what happens is the court then finds the loss amount, adopts the what's in the PSR that's very well supported, and it's
I think that was supported by the FBI agent's charts and testimony.
Charts, exactly, Your Honor, and testimony. And then what happens is after the court has determined the range, They then turn to mitigation, where within that range. And that's when he calls Braver. And when the government objects to Braver testifying, the defense attorney's response, and this is at the transcript, sentencing transcript at page 38 to 39, this is mitigation. So this record is clear. They made a strategic choice by the time of sentencing, although they had argued it before, but by the time of sentencing, there's a strategic choice to accept the loss amount and then raise it in mitigation. And that was a smart choice, or a reasonable choice, because there was, as the district court repeated at sentencing what she'd said at trial, which was, there's no foundation for this. I do not find this to be anything that's worth relying upon.
How do we deal with our case law then, talking about preserving, at least to making it more of a forfeiture issue if you file written objections in
I
advance?
don't read the case law as being that clear, Your Honor, saying that
It is
this
a little
is
murky.
it certainly says it, but I think if you have I would say that this is an exception to those kind of cases. And to the extent there's ones about filing something before, there's just as much ones that when you're asked, I would argue that when you're asked repeatedly at sentencing, in a record like this, where you've raised it before, and now it's sentencing, you keep getting asked and you don't raise it, and then you say you're raising it only in mitigation, that's showing you have now, this isn't forgetting, you were aware, you wrote something and submitted it.
Should there be some obligation to have the defendant withdraw the prior written objections in order for it to be a waiver versus forfeiture issue?
I don't believe so, Your Honor. Not on a record as clear as this. I mean, a court certainly could do that, and that would
be
leave
clear.
no question. But I just think
We like clarity.
of course. But even if we turn to plain error here, even without plain error, that the defendant has to show on appeal that it's outside the realm of permissible computations, but would be under plain error. There is nothing in this record to suggest that Braver's estimate that $4.5 million of the $5 million was spent on business expenses. That's totally unsupported.
But
And
this is a weird record, because it's hard to find much of this money going to him. And the district court judge mentions that. Doesn't seem to have been lining his own pockets. I'm just trying to figure out what happened to this $5 million and some over the course of 13 years or whatever.
Well, nobody is suggesting that he took the money and ran to Hawaii or opened, did a castle. But there's human nature can be run on many different things. And for example, we know, first of all, we only have bank records from 2007.
$200,000 at one point.
In 2008, when the defense counsel says they ran out of money in 2008 and couldn't pay Greaves, well, he transferred $200,000 in that year to his own personal bank accounts, and $75,000 of it during that very period when he's not paying Greaves. So, did he spend money? He spent money to make money, essentially, I would argue. He spent, money on this warehouse to produce a product he didn't have. He spent money on, making hollow frames that he could use in videos. He spent lots of money on videos to raise money.
And this is all, that's why I say it's a somewhat strange case. You're used to seeing people with these schemes who live a very luxurious lifestyle because they're taking other people's money to do it with. You can understand why he is emphasizing, hey, I was just an entrepreneur. I kept, I was a person full of hope. I kept thinking it was going to work out. Never did. And then all of a sudden the government swooped in and indicted me. So of course it wasn't going to after that. You have to be taking a position that it really actually doesn't matter what happened to the money.
Exactly. And it doesn't matter what happened to the money. It doesn't matter what his motivation was. He could, humans are complex. Maybe he just enjoyed feeling like he was the next Steve Jobs. Who knows? Doesn't matter. He lied to get money. And the juries, the court has pointed out, the evidence, that we're on appeal, and the evidence and inferences from it amply support the jury's verdict.
Can you talk in that connection about the last paragraph of this good faith instruction?
Yes.
Honest and genuine belief that you're going to be able to perform is not a defense if you also knowingly made false and fraudulent misrepresentations. He says, one lie and you're out the window.
Nothing in that instruction says that. If defense counsel has a problem with one material misrepresentation being enough for a fraud, his argument is with the black letter law in the elements instruction, which says that. It says that the government has to prove a scheme to defraud, and it has to prove a material misrepresentation as part of that fraud. So his argument is with well-established black letter law. It's not with the honest belief instruction.
The Third Circuit withdrew this paragraph.
Yes.
I don't know if it was identical, but it was similar.
It was.
From its pattern jury instructions.
Yes.
And I know they had the tax fraud case, which
Yes.
was different than this.
Yes.
But then they went and withdrew it from
Yes.
their pattern instructions. Is
Yes.
that a flag for us that there's a concern with this?
I tried to look into that. I
did
actually
too.
even contacted the U.S. Attorney's Office there to try and, they just don't have any information about the rationale of that committee. So all we really have to go on is this case, this Basel case. And what's interesting about it is, in the context of that case, it's not clear that they gave this honest belief instruction in the context of a whole good faith instruction. It just looks like they just isolated this one instruction. And the court in Basel doesn't consider it in the context even of the elements instructions. That's not this case. This
Separate
case,
from this case, is there some concern we should have about this paragraph in the pattern jury instructions?
you know, I don't believe so. I believe it's a clear instruction, especially when given in the context. This circuit's instructions don't suggest that it be given out of context of the good faith instruction. So in that context, it's basically supporting the clear law, which is that you can have whatever good intentions you want. You can believe you're going to produce this product at the end of the day, but you can't lie along the way to get there. And
So
in this,
the instruction troubles me because I think it is a little murky. I can come up with ways of understanding it that would be consistent with the law, you know, so if you think you're going to pay back all this money and so on, that doesn't. So that's like that you will be able to perform what you promised. That's a vague statement.
well, you know, certainly the government's not going to stand in the way of the court, you know, contemplating it. But in the context of this case, there is no way it could be construed as now saying that, you know, one misrepresentation and you're out, and much less one trivial misrepresentation and now you've got a conviction.
And notice you've just added a word. This instruction just says if you also knowingly made false and fraudulent misrepresentations. There's nothing about materiality.
Well,
in that sentence.
not in that instruction. However, then this was our point. All instructions have to be read in context of the instructions. And the instruction just preceding it, the good faith, talks about the allegations that were false in the indictment. And then, of course, there's the clear instruction to the jury that they have to find a material misrepresentation.
And
So-
the prior paragraph of this instruction makes it clear that they still have to prove, that the government still has to prove beyond a reasonable doubt that he acted with the appropriate intent to defraud,
Absolutely.
which picks up some of that.
Absolutely. And so you know, as this court's case law makes absolutely clear, again, is that it's got to be read in the context of all the instructions. So in that context, in this case, the parade of horribles that the defendant is presenting to this court just have no basis on the record. Moreover, even if, you know, the evidence here of fraud and material misrepresentations in support of the jury's verdict is just overwhelming. And on that issue, I know counsel spent a lot of time on sufficiency of the evidence. I haven't addressed it. If the court has any questions about anything, I'd be happy to. But the government argued from the get-go, and this, you know, one thing that they say in the reply brief is that, you know, we've created a lot of this on appeal. Everything in our brief came from what was in the trial record and you know, argued to the jury. And I'd cite to the court, I believe it's page 1597 if I'm remembering it right, but we argued right from the get-go that this started in 2003 with the Phantom. And the Phantom in particular, just briefly, it was the Voyager at Zentek. So when he comes and he starts this company in Armada, he renames this product the Phantom. And the testimony was from the person, his one employee, Vanderzee, who had been with him at Zentek, came with him to Armada. And it's Vanderzee who testifies that product that we've now renamed the Phantom was completely outdated in 2003 when he did this private offering memorandum. There were faster computers with longer memories, and we did nothing to update it. And yet he said, and for this one, Judge Wood, he didn't just say it was approaching market readiness. He said it was market ready, and that it had capabilities not in any other, laptop out there. So
Why charge as one big scheme as opposed to breaking it down?
I think because it is one big scheme. I think that it started in 2003, and the pattern was identical.
You've got different products, different companies.
Not
And
really
not
different
nearly
products.
as many
different-
as examples from the early end of things. You have lots of examples as kind of starting in 2008 till the end, but it's a little thin. the
Well,
beginning.
2003, it's all the way through, though, Your Honors, because it starts with the Phantom, but then you've got the Radian, which, when he ultimately starts Ideal Future, not only does he tell the Armada investors, this is just a renaming. It's essentially the same business. But he also tells them, and I pulled out the site for this because it's in our, I want to say it's in our appendix at 85, I believe, if my memory is serving me, that basically he tells them the Radian that we did at Armada, it's going to be a docking station now for the Dragonfly. And in fact, one of the videos we supplement the record with, the Blackbird video, shows the Radian is now the Blackbird. I mean, these when you say separate products, they're not. They're just continuations. The Dragonfly was the Stealth at Armada. It's all just one continuation of basically material lies to get money to make his dream. Who knows? But it's just lie after lie after lie about these products that start, with the Radian. The Radian continues all the way through Ideal Future. The Stealth continues all the way through Ideal Future. And the evidence is it was one scheme, one single scheme. In fact, Your Honor, to answer your question too, to charge them separately wouldn't have told the whole story. They would have had to get the other stuff in as 404B to show that because they were all so intertwined, really intertwined in this case. So unless the court has any other questions, the government would respectfully request that you affirm his conviction and sentence.
Thank you, counsel. Mr. Lembo, anything further?
Yes, Your Honor. I'd like to start, Your Honors, with the good faith jury instruction, because this is a critical issue. The instruction itself states at the very end that a defendant's honest and genuine belief that he will be able to perform what he promised is not a defense to fraud if the defendant also knowingly made false and fraudulent misrepresentations. And the effect of this is that the government could identify a single misrepresentation and say that establishes not only the scheme, because the government says that one material misrepresentation is enough to convict over a 13-year period, but also Mr. Badio's intent in making his statements.
But what do you do with the preceding paragraph, which absolutely clearly says the defendant does not have to prove his good faith, rather the government must prove beyond a reasonable doubt that the defendant acted with the intent to defraud? I mean, it's not like this additional sentence erases that other part of the instruction.
Your Honor, the issue is that by focusing on Mr. Badio's good faith in bringing a product to market generally, it takes the attention away from his faith in making each individual statements.
But you can't read jury instructions in isolation like that. The law is crystal clear that we read them as a whole. And the prior instructions clearly lay out the elements before you get to this. And as Judge Wood pointed out, that second paragraph makes crystal clear the government still has to prove the intent.
Yes, Your Honor, but the last instruction, even in the context of all of the other good faith instructions, turns the jury's attention away from Mr. Badio's good faith in making the individual statements with which he's charged, as opposed to his intent over the entire overarching endeavor. And, Your Honor, the Third Circuit, this was in the context of their entire good faith instruction. They had multiple good faith instructions, and they struck this paragraph out.
We don't know why. There's nothing indicating why they did that. And the Basile case that you rely on doesn't help you because that's a tax fraud case.
Well, the comments,
Where
Your
good
Honor,
faith is a complete defense. That's
the comments, Your Honor, when it was removed, stated that it was removed because the Third Circuit observed in the Basile case that this language was confusing, even though the court found it was harmless error.
why haven't you? I want to switch real quickly. Why haven't you waived your restitution argument? You didn't object to it in writing. You didn't object to it at sentencing, and you strategically tried to get no jail time based on the argument that your client could pay back the restitution if he were able to work. Why isn't that a pure waiver of restitution?
I would have to look into that further, Your Honor. I don't have the exact answer for you sitting here today, but I would say generally there were objections to the loss amount, and he made it very clear that that loss amount should not be as large as it was. Whether that implicates restitution, I'd have to follow up with Your Honor.
Mm-hmm.
And if Your Honor,
Thank you, Mr. Lembo. And Mr. Lembo, the court appreciates your willingness and that of your law firm to accept the appointment in this case, and your assistance to the court as well as your client. The case is taken under advisement.
Thank you, Your Honor.
Next up this morning is Consumer Financial Protection Bureau against Consumer First Legal Group. Mr. Lovey.
Morning, Your Honor. May it please the court. John Lovey on behalf of the defendants. I'm going to start with restitution, or as we like to think of it, a do-over appeal. This has been decided, and there's no reason to believe the court got it wrong the first time. And I just want to sort of distill what happened here. In the court below, for a long time, the plaintiff pursued a remedy. The court agreed with them and gave them that remedy. We appealed. They defended that remedy. We had a whole appeal. And Your Honor said the way we're going to measure restitution for that remedy is net profits. And
So why isn't the approach that was taken recently in the FTC against Credit Bureau Center case equally appropriate here? Yes, there it had been a big focus on 13B. Supreme Court came along and said wrong, but on second time around, the court says actually Section 19 is also available. Here, we have this almost angels dancing on the head of a pin discussion about the difference between equitable restitution and legal restitution and all the rest of it. But we sent this case back to the district court, and I don't see anything in the opinion that says you are confined to the world of equitable restitution.
Well, the difference between the case Your Honor cited was there was a change in law after the court had ruled. In this case, lieu was decided prior to the ruling. So there was no occasion or justification to go back and start all over on remand.
But we would have to agree with your premise that he's limited to equitable relief and that we limited him to equitable relief in order to agree with that.
Where I started was they sought a certain set of relief, and this court said the way that relief will be measured is by net profits. And the only reason there even was a remand...
But we said that we understood, or the district court understood itself to be awarding equitable relief, which is why we applied lieu in the first place.
Well, I have three responses to that on why the label would matter. The first is they argued last time, to the extent the district court thought it was equitable, we should recharacterize it as legal in light of lieu, and you could affirm it on that basis. And Your Honor said no. They tried, and they lost. But for the fortuity that net profits hadn't been calculated the first time, there wouldn't have even been a remand. Your Honors would have entered judgment on net profits. It was just a coincidence, a fortuity, that we didn't know net profits because it hadn't been litigated below. That's the only reason.
I'm not sure we said that, but go ahead.
But if you had known net profits, there wouldn't have been a remand to calculate net profits. They would have been.
No, I mean, this was all based on the premise of what we review actually what district courts do, not what they might have done or could have done. And what we thought the court was doing was looking at equitable restitution. Frankly, I mean, these are just like musty old distinctions about
Right.
juries deciding things and judges deciding things. What Judge Conley does on remand here is he says, okay, I understand Lou is there now. I understand this remedy is off the table, just as happened in the credit bureau case. But he takes another look at it, and the statute actually allows for quite a few different things. The statute allows even for remedies in the nature of a refund. And so what it seems to me that the judge does is he says, he accepts part of your argument, that there was some value and a 100% refund wasn't called for, but he kind of ballparks it and he says 50% is what it's going to be. And then he follows our instructions. He goes to the strict liability standard, but he uses a different discount factor. So overall, he cuts the remedy in half.
Well,
It's a pretty
I
generous
do want to
half.
return to the point, though, that there would not have been a remand but for the fact that we didn't know net profits.
don't
I
know.
think
Why
trying to
would there be?
second guess what we would have done in an alternative universe is not productive. Let me ask a follow-up to Judge Wood's question, which is, did you offer the district judge some means of estimating consumers' loss and compensating it?
Well, what we did was follow Your Honor's instructions to recalculate net profits, and we adhered to that strictly.
But could you answer my question? Did you offer the judge a means of calculating consumers' loss?
What we did, Your Honor, was we said the
The
burden is
answer
on
is
them.
either yes or no, and
Yeah.
then you can explain.
The answer is no, because the burden was on them to prove a.
I'm sure each side thinks the burden is on the other.
Understood.
But I just need to know what's going on. You have to understand that from our perspective, the sense of déjà vu is overwhelming. You're here arguing that the only remedy is zero, just as the last time. And the Bureau is here arguing that the proper remedy is 22 million, just like the last time, just as if the prior proceedings really hadn't happened. And that leaves appellate judges in a sense of some unease. I
Your Honor,
hope you can understand why.
We are arguing that the remedy is exactly what Your Honor said it was, net profits. You sent it back
But
to calculate
what you're
net
not paying
profits.
attention to is what Judge Easterbrook is saying. Your position all along has been that the work that your clients did was not a total loss for consumers. But it wasn't a total gain for consumers either, or so the district judge has consistently found. And so if you're focusing on loss to consumers, maybe 50% isn't a bad, guess.
Well,
It's imprecise, but the burden of going to each single person and figuring out what was done, for whom was it worthless, for whom was it helpful, isn't something the judges necessarily have to do.
Well, I take it back to déjà vu because I read CFLG 1 very clearly and very carefully. And it said, we disagree with the government's position that revenues and losses is what measures it. It is net profits. That's what Your Honor said. There's no reason to change that.
Is it your position that lieu applies to legal restitution as well as equitable?
Yes, Your Honor. Restitution is restitution is restitution. The distinction is artificial.
My goodness. Gareth Jones wrote a treatise about restitution that's more than 3,000 pages long. I don't think he would agree that restitution is restitution is restitution. There are lots of sub-issues.
Your Honor?
And a big difference between equitable and legal.
Your Honor, in 1939, when the courts of equity and chancery merged, it became less relevant because the body of restitution became the same. But what is not changed, what has not changed though, is the way that it's
You don't have
calculated.
tracing issues. There are material differences.
There are, absolutely are, but not in how it's calculated. There are differences in the reason the distinction has become less important and that we haven't bumped into it is because maybe it's relevant to whether you get a jury trial, but how you calculate restitution, and there's a whole treatise on this, that the restatement third of restatement and unjust enrichment, it is calculated by the defendant's gain, not the plaintiff's loss. There is no body of law, no cases that say that you calculate restitution differently, whether you're talking about equitable or legal. Yes, there's a difference. and it is on the head of a pin because it's sort of artificial and it hasn't mattered in 85 years, but it's not how you calculate it. The way you calculate restitution, whether you're in a legal or an equitable box, is by the defendant's gains, not the plaintiff's loss. Otherwise,
But
it's
we
just
aren't
compensatory
stuck
damages.
with that. I mean, what about Section 55? It allows, for these cases brought by the board, it allows courts to, quote, grant any appropriate legal or equitable relief. And it gives all sorts of examples: restitution, refund of monies, lots of things. So why not on remand, as the district judge is saying, you know, maybe some value happened, not nearly what should have happened, there were problems with this business model. The judge decides that this refund type measure is the most appropriate.
I think the primary answer to that is CFLG 1.
But I don't
Your Honor
know.
wrote an opinion saying
I know the opinion I wrote. I
Yep.
mean, and this panel speaks as a group. You know, these are not, you know, my whims out there, I assure you.
And Your Honor said that given the totality of the remedy being sought here, the way we are going to measure it is by net profits. And we'd ask you to follow.
Following Lou, no, it just saying, if this is an equitable restitution case, Lou tells us that it's got to be net, not gross.
Well then, Your Honor, I
I
would fall
think,
back
Mr.
on
Lovey, that arguing with the panel that issued the opinion about what it wrote is not a productive strategy. If
What-
you have some other arguments, I suggest you make them.
I will, Your Honor, and I think that the main argument is they pursued a remedy. It's what I clunkily called the law of the case forfeiture box. They got in front of the court last time and argued that we are pursuing a remedy, and Your Honor said that remedy is calculated by net profits. If they were actually seeking a different remedy and on a remand they could start over, then they've forfeited it. Because if they were seeking legal restitution the first time in a way that could be calculated differently than net profits, which it can't be, then it was incumbent on them to do that during the first appeal.
I think the problem is that before Lou, there wasn't a distinction between legal and equitable restitution. And so in the district court, before you came up here the first time, going back and looking at the transcripts and what's available, the argument was for restitution. Nobody was making this legal or equitable distinction because it didn't matter until Lou. And then when you came up here, the Supreme Court had decided Lou, and we said Lou applies when you're seeking equitable relief, which is what the district court understood itself to be awarding.
Lou was decided before this appeal. And Your Honors nonetheless said we are not going to recharacterize what the relief you got as legal. It was decided before, unlike the case that Judge Wood brought
We
up.
addressed the issue that was before us based on what the district court had done. And the district court, based on the cases cited in its opinion, was addressing it as equitable relief.
Because-
it's not up to us to recalculate damages.
That's what they had sought, that's what they had won. And that's what Your Honors were
As
called
I
on
say,
appeal.
Mr. Lovey, if you have some arguments that don't depend on arguing with the court about what we said, I suggest you make them.
Well, I do believe that either they forfeited it by not bringing it up the first time, or if they did pursue this remedy the whole time, then they've lost it as law of the case, because this panel's opinion would cover it. And I believe that when they said the first time, hey, let's recharacterize it as legal, and Your Honor said we reject that argument, that they were not free on remand to start all over again. Not free on remand to say we'd like to amend the complaint and throw out a new theory because we didn't appreciate that Lou had this distinction, which it didn't, because I'll end on that point. Legal and equitable restitution is calculated the same. On the merits, it wouldn't be different if in fact it was legal restitution. The restatement third, section 49 says the way you calculate restitution is by looking at the defendant's gain. And here, the defendant's gain was 0. So even if it was legal, they still don't get where they need to go. There's no dispute that restitution under legal is also judged by net gains and that there are no net gains. I want to talk also about penalties. There is, if the district court is correct, there's $18 million worth of penalties on behavior that warrants no penalties. The defendants provided these services They spent this is not a case where they took the money and ran, where they defrauded anybody. They took $20 million in fees and spent $20 million providing these services. There were 1,500 clients who got mortgage relief. All of those clients, the district court said, I'm going to not only take away all the money you spent providing it, but I'm going to penalize you $2,500. There is no universe where that makes any sense at all. There's no penalty justified at all. The only offenses for which they're being penalized are taking advance fees, which lawyers can do, not disclaiming in their retainer agreement that they're not going to take advance fees, and telling people that they're lawyers who are going to practice law.
So you're almost out of time, but I'm just going to comment maybe for your rebuttal that a lot of the arguments that you make in your brief along those lines, despite your disclaimers, feel to me like they are relitigating liability, that it's not just a remedial point.
Now, our position
you
is...
You can do that on...
Sure. We've lost liability. Restitution is appropriate,
Right, and
however
you're
your
not
honors
accepting.
decide to measure it, but there's no penalty-worthy behavior, and I will save for rebuttal.
Certainly, counsel. Mr. Friedel.
May it please the court, Kevin Friedel for the Consumer Financial Protection Bureau. In the prior appeal in this case, the court affirmed that defendants were liable for numerous violations of federal law and affirmed that when they committed those violations, they were not engaged in the practice of law. Those issues have been resolved definitively. The only questions that remain here is the appropriate amount of redress that defendants should have to give back to the consumers they harmed, and whether the district court abused its discretion in setting civil penalties for defendants' violations. I'm going to start with the redress point, where the district court properly ordered legal restitution or refunds on remand, but erred in setting the amount of that award.
But what are we supposed to do with this? The judge seems to have pulled this 50% figure out of the air, and there isn't any explanation. One can speculate all day long, but why is that good enough?
Good enough? It was not good enough, Your Honor. And in our cross appeal,
I mean, it may, if we did send it back to the district court and it just elaborated on why it picked the number it did, you wouldn't be any better off than you are right now.
well, I think it did elaborate. It gave its reason, which was that this court had found in the prior appeal that the violations weren't reckless, and reducing the restitution award on that basis was legal error.
That's relevant to damages, not to restitution. Right? I expressed some frustration to Mr. Lovey that after our appeal, he just maintained the same position that the damages are zero. I have the same frustration for you. After our appeal, you maintain the position that the restitution was just the same as it was before. That our opinion didn't do anything. Did you offer the district court some means of trying to figure out what consumers lost?
Your Honor, restitution is measured by unjust gain, so that is what our arguments were directed to, not consumer loss.
District court thought that legal restitution is measured by consumers' loss. That's what he wrote.
Well, I think, Your Honor, in this case that consumer loss and unjust gains essentially are the same amount. Because
they can be completely different. Consumers can lose $10 million while the defendant gains zero. Or you can imagine all sorts of outcomes. You can't just assume this problem away. And it may be that the 50% comes from both sides were being absolutist. Neither side was helping me figure out what consumers actually lost. And so I took each side's estimate, added them up, and divided by 2. Because nobody offered me anything else I could do. And I'm trying to figure out whether that's a correct understanding. Whether you offered him anything else he could do.
Your Honor, I don't think it's correct. We sought legal restitution or refunds. Those are determined under a burden-shifting framework. We met our burden to show what we thought was their unjust enrichment. We thought in this case that was the full amount of fees, which were themselves.
I understand that, but
yes.
I wish you'd address my question. Did you offer him anything else other than saying, we want exactly what we got before and got reversed on, and the other side saying exactly the same thing? Did anybody offer the district court any other alternative than all or none?
Your Honor, under the court's burden-shifting framework, no. We asked for
All right,
the
the
full
answer
amount.
is no.
You didn't even dispute their net profit calculation.
No, what we said to the district court was that if that calculation was appropriate, there was going to be a need for further discovery to dig into the numbers that they had provided on remand. They came forward with
It
numerous...
seemed kind of late to start asking for additional
Well,
discovery.
Certainly, Your Honor, but this was what the information, the evidence that they came forward with was not in the summary judgment record, it wasn't in the trial record. They came forward in remand with sort of a wholly new calculation of here is our profits, and we just pointed out, look, we're going to have to dig into that. The court shouldn't take their word for it. We certainly weren't going to. But I think just to maybe return to this all or nothing point, we sought the return of all of the illegal fees that they wrongfully took from consumers.
So I don't
That's
understand
the same.
that. I mean, you've said that now several times, and that's obviously what you did seek. But you're not disputing, are you, that there were more than 1,000 people, I mean, a substantial number of people obtained mortgage relief from their efforts. Could they have done it on their own or on a website or with a free service? Maybe they could have, but they did get a tangible benefit, which was, whatever, the restructuring or the relief on their mortgages. And so for you to say, well, it's the full 21.7 million, and then to say, well, but actually there was value conveyed by this group in some instances, maybe not 21.7 million, but again, there's just no evidence exploring how we're supposed to make these adjustments in the light of at least the philosophy of the Liu case and other guidance that we have.
So I want to address that minority of people who did get a loan modification. Even those people were deceived. Even they are entitled to their money back.
Why? Because they got value for their expenditures. Maybe they overpaid. That happens with cartels. It happens with all sorts of people.
Defendants sold them on this idea that they'd be providing expert legal representation to help them save their homes. Defendants didn't provide that at all. This is sort of analogous to a medical office that promises you care by the best doctors at top dollar. And if you go to that office and you're seen by the file clerk in the billing office, I don't think it really matters if that person happens to correctly treat your...
But did you introduce any evidence? You could, for example, have compared what happened to these consumers with what happened to consumers who applied on the web on free legal services, without paying any fees to anyone. Did you do that and compare what the success rates were? That would be one means of estimating the value of defendants' services.
This court affirmed in the prior appeal that defendant success rate was not different from what was available for free from
that
these
might be the
nonprofits.
basis of an argument in the district court about consumers' laws. But I don't see how it supports, the argument everything they got counts as restitution.
Well, again, Your Honor, what we did on remand
what it would
was...
show is just an overpayment. They
Yep.
paid $3,600 or whatever that average number was, instead of $0 or whatever time they spent, on their computer.
Under the applicable legal framework, that was their burden to come forward and show that our
Yes,
estimate...
I know. Everybody says the other side has the burden. I hope you can see why this is frustrating. Everybody says the other side has the burden, and therefore we don't have to help the district judge. And both sides said that. And we end up here with the sense that we haven't been making much progress.
I think the difference is, Your Honor, our position is actually supported by this court's precedent, including the decision in Trudeau, which talks about this burden-shifting framework. And also, what we saw is essentially the same relief that this court just affirmed in the Credit Bureau Center case. There, you had defendants that deceived people, tricked them into paying these automatic recurring fees. There was only $30 a month. Here, they were charging people up to $1,000 a month. And what the FTC asked for was that they have to give back the fees that they wrongfully took. That's exactly what we asked for in the district court. I know that's what we had asked for in the district court.
But there was no value in the credit bureau case. They lured people in. We'll give you a credit score for free, but in the little tiny fine print, and by the way, we're going to charge you from now to the end of time, $30 a month. For what? For nothing. Here, at least your opponent argues, and the record seems to show, that a decent number of people received mortgage relief. So there was an exchange.
Well, in addition to the point I mentioned that even they were deceived, we don't know if people would have wanted to sign up for this service if they knew the truth. I would again point to Trudeau, where this court said that the burden is on the defendants. This is the court's holding that to get a deduction for so-called satisfied
The statute
consumers.
here is a little broader. It provides that the court could grant any appropriate legal or equitable relief, which is a little broader than the other statute.
I think that's right, Your Honor, and one well-established form of relief is exactly what the FTC got and this court approved in Credit Bureau Center. That's what we asked the district court here.
Given that broader language, why was it error for the district court to discount the amount, the full amount that you were seeking?
One, because we think that defendants had to come forward and justify any offsets, which they didn't do, but also...
And why didn't you, though? I mean, this is what Judge Easterbrook has asked 10 times, but why didn't you help the court? I mean, just resting on burdens of proof is a little risky. I mean, telling the court there was some value, not complete value, and if only the court had explained itself more fully, it'd be a little easier for us to attack this, but the court could well have thought that there needed to be some remedy, but something other than all or nothing was appropriate.
Well, and I don't mean to suggest we're relying only on burdens of proof. We don't think any offsets were appropriate. We think $21.7 million is what they wrongfully took from people, and we think it's a straightforward remedy that they'd be required to give that back as legal restitution or refund of monies. And again, I think as one of Judge Easterbrook's questions to my friend on the other side suggested, that the defendants did not come forward and make any arguments. They didn't engage on what should be the proper amount of refunds or legal restitution. They had exactly one argument, which is that this panel had already resolved this issue and precluded anything other than net profits. And they pursued that litigation strategy to their peril and didn't engage, didn't try to help the district court assess what this
But what's the court's error because you hadn't established recklessness discounting that amount? What prevents or precludes the court from doing that given the inappropriate legal or equitable relief language?
Your Honor, I think that, and thank you for returning me to this point, the fact that their violations weren't reckless just has no bearing on what the Bureau was asking for, which was their unjust enrichment to be returned to the consumers.
But the district court thought that was appropriate. So what precludes? I understand you argued you didn't think it had anything to do with it, but the district court thought it did. Why was that error that the district court thought that was the appropriate legal relief?
Well, we don't read appropriate in the statute there to mean anything that a court wants to do.
But it wasn't anything within the scope of the remedies Congress has made available, which is what Judge Saini said a minute ago.
Right, and the remedies we were seeking, legal restitution or refunds, just do not turn on the scienter of the defendants. That would be inconsistent, I think, with this court's cases about restitution in the context of an innocent recipient. Even that recipient can be required to give back everything that they wrongfully obtained to the person who rightly possesses it. And what it would mean essentially is that had the district court found that these violations were knowing, the district court could have increased the restitution award then under this logic and required them to give back twice as much to the consumers they harmed. And we don't think that would make any sense. We think it was equally error to slash the award based on the irrelevance of their scienter. And I would also point the court to the Albemarle paper decision we cite in our briefs from the Supreme Court and the Ninth Circuit's cash call decision, which really squarely address this and hold that scienter is not relevant to this calculation. So we think that was legal error. That's why we are asking for instructions to the district court to enter an award of legal restitution or refunds for the full $21.7 million. I would turn, if I could, briefly to penalties. The district court significantly reduced the penalties in the first iteration of this case. The total penalties among the 5 defendants were more than $37 million. On remand, ordered just $18 million, which was significantly less than the Bureau sought and about 50% of the statutory maximum. This court made 2 holdings on penalties, one about the number of days that the violations persisted, one about the scienter, and there's no dispute the district court correctly applied those holdings in calculating penalties. So defendants are left to argue that the district court abused its discretion in setting penalties at that level, and they really can't meet their burden to do that. So my time is almost up. I would just close by saying, defendants took advantage of homeowners seeking help to stay in their homes. They harmed them to the tune of tens of millions of dollars in fees, and it wasn't just that. People lost their homes while paying defendants thousands of dollars for help they were promised and never received. All we're asking for is that defendants have to give back the money they wrongfully took. If there are no further questions, we'd ask the court affirm civil penalties and remand with instructions to enter legal restitution or refunds award of $21.7 million.
Mm-hmm. Thank you, Mr. Friedel. Mr. Lovey, anything further?
Yes, sir. Well, both sides think the district court got it wrong and that the district's order on restitution should be reversed. And what this court should do is should send it back. We argued that the district court should do what this court told it to do, was calculate net profits. If the district court's not going to do what this court told it to do, then at least it should get it right. It should determine what is proper restitution, whether you call it legal or equitable, in light of the fact that 1,500 people got exactly what they paid for, 1,500 more submitted applications. The fact is, a lot of money was spent to provide these services, and restitution is the same whether you measure it equitable or legal. So there needs to be one final round where the district court actually does the analysis that this court has alluded wasn't done. It can't just spitball it. It has to actually justify restitution, whether you call it legal or equitable. I want to make a point on the credit bureau case. They had sought refunds the first time. In this case, the CFPB never sought refunds. It wasn't until after the remand. So there was no harm.
Lovey.
Thank you.
The case is taken under advisement. Our third case for argument this morning is Williams against DeJoy.
Good morning, Ron.
I will call your name when we're ready.
Okay.
Mr. Smith.
May it please the court. Again, I'm Michael Smith, representing the appellant Carlos Williams. I have not been on the trial. I've only been on his appeal. I've looked through the transcript on the proceeding, and what I tend to find is that the trial court was very combative with my client. We find that there was a lot of interruptions during the trial. Now, part of that was he was pro se. So the court seemed to be taking out grievances because he didn't have an attorney. But there was
the court actually was trying to help him too. She urges him several times not to open the door on the discussing the incident with the teenage girl, and he pays no attention to what she said. But that I regard as a piece of helpful advice from her if he had followed it.
Your Honor, beside that, there were many other incidents. The opening the door, as you just sort of alluded to, basically he was in cross-examination and examination. He had mentioned that he was actually challenging charges against him in EEOC. Then the court took that harassment as he was going to bring out the incident. They had a sidebar, and at the sidebar, basically, it was just shown by the government that he opened the door, and the court agreed with him. But that was very detrimental, because bringing that out to a jury.
Of course it was detrimental, but it's easy for anybody to read what he said, and it's not the first time any of us have seen such things.
And that's why the court was trying to help him not to open these doors because it was detrimental.
But Your Honor, it seemed to be very innocent what he was doing. He also just said he's trying to
If
defend.
you open the door, you open the door.
But I think, Judge, by looking at the statement by him that caused the door to be open was not actually something that was bringing out the incident with the complainant Meade.
It seemed to me that the district court judge here was quite patient with your client throughout this.
I'm sorry, I didn't catch.
It seemed to me that the district court judge was quite patient with your client.
But it looked very combative, Judge. I mean, at this point, that's what I was concerned about.
That's not really reversible error, though. I mean, what legal things did the district court slip up on, in your opinion?
Well, we were looking at the failure to allow him to have an attorney. He did have one attorney.
He had two attorneys.
He did.
And they both found him too difficult to work with. We have told district judges to stop, that once they have recruited a lawyer and the lawyer asks to be out, the judge should not try again, shouldn't reward difficult clients. And this looks like the very example of why we've given that advice. What's the legal error in following advice from the Seventh Circuit?
In addressing that, Your Honor, basically, he objected to the last attorney based on, he pointed out in his motion to object to the withdrawal, that there were many things that he thought were advantageous to him to be presented to the court.
But the court, here's the problem. A, there is no right to a lawyer in this type of civil litigation. There is a facility for a judge to recruit a willing volunteer to help somebody. Sometimes there's even some possibility of attorney's fees at the end of the line, but it's recruiting a volunteer. And the lawyer is trained in the law, right? So a client may think certain arguments are winners, but they actually may not be for any of a host of reasons. And so if you're given a lawyer and you are appreciating that gift from the system, you need to listen to your lawyer. And as Judge Easterbrook says, there not only is there no right to begin with to a lawyer, but there certainly isn't a right to lawyer number 2, number 3, number 4. Any good lawyer might have the same disagreement with him. In fact, yeah, he went through 3, I thought. But there was the original lawyer, and then somebody was substituted, and then there was the first recruited lawyer. And the judge says, you know, I'm not going to go down this path again. And in so doing, she was abiding by the guidance that this court's given.
But, Your Honor, also the court, in denying his motion for an appointment, also,
there is no such thing as an appointed counsel in private civil litigation. Judges have the statutory authority to recruit counsel. You need to explain to us why it was legal error not to recruit another lawyer when the plaintiff was not following his lawyer's advice.
because in the motion to object, Your Honor, he also listed out things that he thought were going to be advantageous to him.
That he thought. Were you listening to Judge Wood?
Also, in that motion, Judge, it tended to show the court the complexity of the case. And I think that's the main issue.
But it doesn't matter how complex it is. If you have a lawyer who withdraws, essentially because you're asking her to argue issues that she doesn't think she can do under Rule 11. Ms. Brown is a very talented employment lawyer. And from the record, while she was representing him, was certainly beneficial to him. But he wanted her to pursue these double jeopardy and due process issues that she didn't think were appropriate. So he made that determination.
And I will add, to the extent that he has now raised those things, both at the district court and through the brief you filed, these are meritless arguments. I mean, her judgment was very sound.
But getting back to my initial comment about the combativeness in reviewing those transcripts, it certainly came out that she interrupted him many times in his cross-examination.
But you still haven't answered what the legal error is of that.
Excuse me, Judge.
You haven't answered what is the legal error, assuming that's true. And that's not how I read the transcripts. But assuming that's true, what is the legal error?
I believe because of the complexity of the case, and it could be noted by the court that during the issues that were arisen, the court many times had admonished the client about the facts that he was doing things wrong. He wasn't cross-examining correctly, and she basically would take charge. So it certainly interrupted his case strategy or cross-examination.
All right, so maybe we can move off this topic. So one of your big points is that you think that there was a mistake about counsel. Is there anything else you would like to tell us?
Well, you also had the issue of he made a motion to dismiss based on the charges against him were incomplete. He was then charged with being off from June 6th, when he also got a letter, as I've indicated, on June 9th to report back to work. That was then a defective removal.
What statute did it violate?
As far as a statute, Judge, I don't believe there's a statute. I believe, though, it's defective
but
on
this
the
is a case resting on a supposed violation of a federal statute. And it's a problem if you can't articulate what statute the asserted behavior violated. I hope you can see that.
I believe, Judge, that even the agency had pointed out in the motion to dismiss that it went to the heart of the case. If, in fact...
What statute has been violated?
I can't say the statute, Judge. I can only say that even the agency admitted that the case would have been thrown out as almost like a summary judgment in favor of him if they ruled against that agency's incorrect document. So the document is probably not something that's protected by federal law, but I think it's basically a right, an equity right that he has to have a document in front of him that's correct.
He's the plaintiff, and he filed a motion to dismiss, which procedurally makes no sense. That's essentially asking the court to throw out any defenses and find for him. There is no procedural motion to dismiss for plaintiff to do that. And the judge was trying to help him by recharacterizing it and addressing what she thought he might be trying to get at.
In addressing that, Judge, I believe, again, that the government indicated that changing that date would destroy the case. And also that...
12b-6 is a motion for failure to state a claim. He's the plaintiff here. There is no procedural motion to dismiss when you're the plaintiff unless the defendant has counterclaimed, which isn't what happened here.
I don't see...
And certainly no motion just to order judgment for the plaintiff when the defendant is opposing the case.
Excuse me, Judge.
I mean, there is no motion that says, please reinstate me instanter when the defendant is opposing the case. The defendant is taking the position that there are no statutes that have been violated here, in partial answer to Judge Easterbrook's
But
point.
even the agency admitted that if she approved that the charge was incorrect on its face...
That doesn't mean it was discriminatory on the basis of race or national origin or gender. Those are very particular claims to make, and that's what survived in this case.
But that's, Your Honor, that's exactly what caused him to be...
I don't see any evidence of any of those forms of discrimination.
I think it goes also to the fact that he, as we pointed out, was an EEOC representative, and he had represented many people before the same people that had terminated him. So it seemed to be a rush to judgment. Also,
Well, that's a separate kind of claim, which the district court did not leave in the case. It sounds to me like you're suggesting there was some sort of retaliation claim, but
Right.
I don't see that anywhere in this case.
And I think the district court allowed him to bring in the fact of those other complaints that he had assisted in filing, just not the details of them.
Not the details and not all the employees.
Because that would be mini trials that are completely irrelevant.
but that would be a separate issue, Judge. But in dealing with that, it was important to be able to characterize his personal EEOs that he had filed against the very people that were making the determination that he violated the AWL case.
She allowed in the fact of those other complaints.
The only thing that he was allowed to do is give the status that it was either accepted or denied. Was not allowed to go into the elements that would tended to show that the retaliation and the discrimination based
But the
on his-
argument was that the retaliation came because of the mere fact that he filed them.
I think it needs to go, though, to the elements of what was in those charges.
That would create a lot of jury confusion.
But I think it'd be important for the jury to hear it. Maybe a judge could discount it, but a jury is going to give some credence to that. Seeing that somebody is being discriminated against based on the race or based on their prior EEO activities is certainly relevant, I think, to his case.
You're about to run out of your rebuttal time if you're saving any.
I'm sorry, I didn't hear that.
I said you're about to run out of your rebuttal time if you're saving any.
Oh, I'm sorry. I will save it. Thank you.
Certainly, Mr. Smith. You should have a seat at council table, Mr. Smith. Ms. Flannery.
Counsel. May it please the court. Appellant Carlos Williams' appeal is a classic example of everything but the kitchen sink. But this appeal is regarding solely two issues. The court's summary judgment ruling in favor of the Postal Service regarding Mr. Williams' 2013 emergency placement and removal, and the jury verdict in favor of the Postal Service regarding Mr. Williams' 2014 removal. Very briefly regarding the summary judgment opinion. The court properly found that the Postal Service articulated legitimate, non-discriminatory reasons for its actions when it decided to place Mr. Williams on emergency leave in 2013 and then terminate him after he had an inappropriate interaction with a high school teenager on his mail route. The mother reported that she was frightened and that they were concerned that Mr. Williams would return to the home. After an OIG investigation concluded that he did in fact violate policies through his conduct, they terminated him.
Is this really still in the case? I mean, I was under the impression that there were administrative proceedings at the end of which the termination was dramatically scaled back to a 6-day suspension, and then that was more or less over with. You know, what's still here about that?
Yes, Your Honor. So Mr. Williams filed a series of grievances regarding that emergency placement and termination, and the parties had an arbitration where a settlement was reached.
Right.
Mr. Williams was at the arbitration, and they agreed that Mr. Williams would return to work 2 days later.
And this is where he says he was there and heard all of it except for the June 6th reference?
Correct.
Okay.
He was present. He knew he was supposed to return to work. He disputes what day he was supposed to return to work, but that doesn't change the fact that he never came to work for 2 months. He didn't respond to his supervisor's attempts to reach him, and he never submitted any documentation substantiating his absence. And so the jury was entirely correct. The verdict was, there was no error in when the jury ruled in favor of the Postal Service because Mr. Williams failed to come to work for 2 months in 2014.
So did Mr. Williams introduce any evidence tying either of these events, the 2013 or the 2014 dismissal, to any protected characteristic under the statute?
No, besides his own say-so, no, there was no testimony or evidence from his supervisors, anything to that effect. I also
No
want
comparators, no, or
Your Honor, he did call a comparator as a witness, two comparators as witnesses, but they testified about why they missed work, the circumstances for them missing time at work, and why they had FMLA leave, or why their absences were excused, yet Mr. Williams were not. So he did introduce evidence of comparator, but it didn't persuade the jury.
it seems like this was all happening, the 2014 return to work and all the rest of it, a very difficult time for Mr. Williams since his wife had recently passed away.
Yes, Your Honor. His wife had unfortunately passed away shortly before the arbitration, but at no point at that arbitration did he ever say he couldn't return to work. And so while he may have been going through a difficult time, you have to actually tell your employer you can't come to work, and he never did that. And so, and any medical documentation that he had regarding his inability to return to work was submitted months after the fact and after his termination was effective.
Can you, speaking of months later, can you explain to me the back pay issue? Because in the government's brief, there's this kind of breezy little statement that the back pay was never paid. And it seems like in 2018, he did fill out the paperwork for it.
Yes, Your Honor. So at the arbitration, they agreed that Mr. Williams would receive 50% of his back pay. Mr. Williams repeatedly objected to the calculation of the back pay. He objected to that calculation for 4 years through counsel. He refused to sign the paperwork. And so Postal Service did not pay him the back pay because there was no an agreement on how much that was going to be. It was only after the case had been filed in federal court and the parties were in discovery and the case was proceeding did Mr. Williams decide to sign the back pay paperwork and submit it. And so he makes issues about, he raises issues.
I mean, at that point, I mean, it's probably outside the record, but was it paid?
No, he was not.
Yeah, so it's just not paid, huh?
No. He wanted to introduce evidence of that back pay paperwork at trial, but whether or not he signed paperwork in 2018 had no bearing on his 2014 termination. I just want to briefly discuss the issue, two issues. One is this idea that there was defective documents, that there were paperwork that wasn't filled out when he was removed from his employment in 2014. Whether or not Mr. Williams has a due process claim, he was able to raise those arguments and make whatever arguments he wanted to make through witnesses at trial. He asked those witnesses about why they filled out documents the way they did, if they were in line with Postal Service policy, and they answered those questions and they explained it to the jury. So there's no error, there's no prejudice regarding these due process defective document claims because the jury heard that evidence. And lastly, regarding opening the door evidence, prior to trial, Mr. Williams sought to exclude one letter from the young woman, the letter articulating what happened. He did not seek to exclude the events that happened in 2013, but the court excluded it nonetheless. And the court repeatedly warned Mr. Williams about not opening the door. But he got up on the stand and he immediately started testifying regarding those 2013 events. He wanted to discuss those issues, and he did. And he was able to explain to the jury his view of events of his interaction with that young woman. And so he cannot articulate prejudice as a result of himself opening the door. And finally, my last point, Mr. Williams has waived arguments regarding the weight of the evidence or the sufficiency of the evidence because he didn't file any post-trial motions through counsel, which he had. And if the panel does not have any further questions, we request that the court affirm the district court's award of partial summary judgment, affirm the district court's pretrial rulings, and affirm the jury verdict in favor of the Postal Service. Thank you.
Thank you, counsel. Anything further, Mr. Smith?
I certainly appreciate the time to appear before this court. Counsel's pointed out about his missing work and things like that. He was going through a very difficult time at loss of his wife and burying his wife. he, in opposition to what counsel said, he then was calling in once he knew about when he was supposed to come back to work. He was calling in on a landline quite a few times looking for FMLA right. He then never got a response from them, but he did attempt to get additional time to return to work. As far as the defective document, I think I covered that pretty extensively. I think counsel didn't really cover the motion to dismiss like I believe that I did. I don't have much more that I can give the court in the few seconds I got left. I didn't mean to go over, but thank you again for allowing me to appear, and we hope that the court will take in consideration the things that have been raised in our brief and then reverse the judgment. Thank you.
Thank you, counsel. The case is taken under advisement. The next case for argument is Aluminum Recovery Technologies against Ace American Insurance. Mr. Young.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court, Douglas Young on behalf of Aluminum Recovery Technologies, Inc. We're here today regarding our appeal of a partial summary judgment grant by the District Court. We've asserted that that grant was in error, that there was credible evidence creating a genuine issue of material fact, and that this case should have been allowed to proceed to trial on these two remaining issues. As we explained in the brief, the majority of the case has been resolved by settlement. These two issues were not resolved because they were granted summary judgment, and we then appealed after the resolution of the remainder of the case. What we're talking about here, Your Honors, is an insurance policy issued in Indiana. Indiana law applies. It's a slightly unusual policy in that it's an all-risk policy tailored to foundries and metal smelting operations. What brings us here is a somewhat unique exclusion for refractory. Refractory and catalyst is not covered under the policy, and the reason for that is refractory and catalyst are often used up in the smelting process. They will wear out and need to be replaced, or be, in the case of catalyst, subsumed in the smelting operation. So this exclusion was intended to apply to situations where natural wear and tear, the refractory goes away and has to be replaced. But there's an exception to that exclusion for 13 enumerated events: riot, lightning. The one that brings us here is explosion. In the briefing, you can see there was the district court level. The district court judge relied on the insurance company ACE's expert witness, who did not believe that an explosion occurred, but he didn't interview any of the people operating the equipment at the time.
Like in the causal chain, I mean, I think the district court found, a lack of proffered evidence that would have allowed a reasonable jury to find that the explosion, that the sequence basically is explosion and then damage to the refractory lining, as opposed to other problems that may have been there. Everybody seems to think it was bad welds and the temperature of the molten aluminum going in there. So you have to come forward on summary judgment with the evidence that you think the jury is going to credit.
Yes, Your Honor, and I believe we did so in that it ultimately comes down to a chicken or egg type of analysis, which came first. We
No,
have-
it's not a question of which came first. It's a question of what caused what. The language in the policy speaks of damage, quote, resulting from, close quote, an explosion. So let's assume an explosion came first. If it didn't cause the damage, it's not covered. What is the best evidence in this record that an explosion caused the damage to the refractory lining?
Well, Your Honor, I believe the best evidence of that is Mr. Sales, the party that put the refractory in initially and then ultimately replaced the refractory.
But his opinions were expert opinions that you didn't disclose.
That is true, Your Honor. They were fact witness opinions. He was the person that put
No, I
this
didn't say
refractory
they
in.
were fact. I'm sorry. Mr. Sales's opinions about what caused it, and we can talk about whether or not those were dispositive or not, but he was not disclosed as an expert, and those opinions about the cause were expert opinions. That's why the court didn't consider his testimony.
You are correct, Your Honor. Although what I was going with there was Mr. Sales' knowledge of how this refractory, basically a cement, works.
But that's exactly, I mean, it's the come-ho-tire type of expert testimony. Somebody who's just very experienced in the field, who knows, as you just said, how these things are put together and how they work. But they count as experts every bit as much as some professor from an engineering school would count as an expert. The Supreme Court's been very clear about that. And he wasn't disclosed that way, so he couldn't offer, this isn't within the jury's ordinary lay knowledge. It's not like jurors sit there with these refractories. It's a complex business that your client had.
Well, Your Honor, I would respond to that by Mr. Godoy, the expert for ACE, he did in his deposition testimony acknowledge that an explosion can damage the refractory. Here,
But that doesn't give you causation, because you have to show that, in fact, this explosion did cause the refractory lining.
And Your Honor, for that, what we're using for causation is the time element of, we have an explosion, we have a leaking furnace within a very short period of time.
That comes back to the problem, though, of did the explosion cause the problem, or did something else cause it?
And there's evidence in the record that it could have been something else, and that's why I'm saying you couldn't just sit there and say, oh, maybe the jury wouldn't believe that. You have the burden of proof. You have to show the court what's the evidence, if there were to be a trial, that you would point to. And you need more than just this guy saying, I heard an explosion, because there's evidence in the record that indicates that could have been after the leak has already occurred and the aluminum is leaking away through all of this and hits the concrete and makes the very loud noise.
Well, Your Honor, with regard to that, Mr. Godoy did testify that he believed the explosion was molten metal hitting the hot concrete, or the cold concrete, pardon me.
The cold, yeah.
However, there was no testimony. The witnesses who were operating the furnace, one of them stands near where the leak was. They did not testify that there was any explosions coming from the cement.
But the leak has to have started inside. I mean, it takes it a bit of time to get all the way down to the concrete.
Well, Your Honor, that would be true, although the person who was standing near where the leak was would presumably have seen the molten metal exploding off the concrete. They were not far away. That what the testimony from the supervisor, Mr. Mosley, was that he heard a large explosion, and he did candidly concede that there are small explosions, not infrequently, in these refractory type operations, small popping,
More
which
like popping things, yeah, from the moisture, right?
Yes, and this was February. What they do is they store aluminum shavings, for the most part, outdoors. It gets wet, icy, snowy. It's brought inside. It should be allowed to dry and demoisture itself, for lack of a better term. And then it's put into the other molten metal in the refractory. Mm-hmm. If it's put in when it's wet, it would be akin to throwing water into a pan of grease. There's going to be an explosion. And that's what he testified, Mr. Mosley, had occurred. And that within an hour, leaking was observed. And it's our position that the explosion causes both the refractory to fail, which is the concrete.
What is your position based on? Your brief reads as if you're arguing something like res ipsa loquitur, but this is far too technical to say the event speaks for itself. Was there any causation evidence that the district judge didn't exclude?
Well, Your Honor, I believe there was, and that would be the circumstantial evidence that we have, and I believe we've cited in our brief that circumstantial evidence can be used in rebuttal of a motion for partial summary disposition.
Circumstantial evidence showing causation how?
That we have an explosion, we know that the refractory is made of concrete, for lack of a better explanation, and that it has a weld underneath it. Both an explosion can cause the weld to fail. It could have been a bad weld and still fit within our theory of what happened here. The explosion caused the bad weld to fail. The concrete cracked, the material
How
came
does
up.
this show causation? You know, as you know, in logic, there's a logical fallacy that goes by the name of post hoc ergo propter hoc. And it sounds like that's what your argument has devolved to. One thing follows another, therefore one thing caused another. And it's just a fallacy. You need some evidence. That's what I'm asking you for. Is there any evidence?
Well, Your Honor, I guess the evidence I would suggest to the court is this was a brand new furnace being loaded for the first time. That there is no evidence in the record other than Mr. Godoy saying that he doesn't believe an explosion occurred and he doesn't believe that an explosion could have caused this.
All right. I think we have your position. Thank
Your
you.
Honor, and if I may move on to the next argument.
No, your time has expired,
Oh,
counsel.
I'm sorry, Your Honor.
Mr. Orlando.
Good morning, Your Honors. May it please the Court, Tom Orlando for Appellee Ace. There is no evidence on causation. I think in the reply brief of Art, there's a very telling statement that Art proffered testimonial evidence of a large explosion immediately preceding the noted failure of the welds in the area of the furnace's recent expansion, the noted failure. We take as a given that there was an explosion. That's how the testimony came in. The district court had to accept that Mr. Mosley heard this explosion. At some point after the explosion, he noted leaking aluminum.
Can I ask you a question about the way this policy is worded? It's a little bit funny. It excludes any refractory lining, as we know, except for damage directly resulting, and then it doesn't say damage or destruction directly resulting from, for example, explosion. It says resulting from the perils of fire, lightning, windstorm. Is perils just superfluous? What are the perils of explosion as opposed to just explosion?
Perils is an insurance term of art. I think all of those things that are listed in that exception are perils.
So what is perils of add?
Maybe not too much, but
Okay, if I can just mentally delete it, it will scan a little better for me.
So what Mr. Mosley could not do, there is no testimony by Mr. Mosley, by any of the workers, as to when the leaking actually started. And so they don't have that causation element. What Mr. Godoy did, who's ACE's expert, is to explain what would have happened if it really was an explosion that caused this, why he doesn't think this was an explosion. But the burden was not on ACE to even go that far. The burden here was on ART to establish that an explosion caused the failure. And there simply is no evidence of that. Mr. Sale, who is quite knowledgeable, who was not disclosed by them as an expert, but clearly is knowledgeable, for early on he said it was defective welds. Even before ACE's Mr. Godoy reached that conclusion, Mr. Sale immediately said that it was the defects within the weld.
So the notion is they pour this stuff in and the welds are bad and it splits apart and the leaking starts.
Yes, the
before
pressure.
any kind of explosion happens.
That's right. And a picture is worth 1,000 words. If you look at the photographs
I
and
did.
put them in the brief, it's a surgical line where the weld is. That's a common layperson could probably look at that and say, that's not an explosion.
Well, I must say, I don't think your common layperson knows what explosions do. Explosions create overpressure. And overpressure might cause a weld to fail in a straight line. That's an engineering question. It's not something you would ask the proverbial man on the street. I mean, I'm a little troubled that both sides seem to be thinking that we lawyers know enough about engineering to have a view on this.
I actually agree with that, Your Honor, and I would say that's not ACE's position. Our position is that you need to have an expert for this. My only point is if we are to credit Art's argument that a layperson could understand any of this, I think a layperson would not look at that picture and think that's an explosion, but that goes to your point that you would need an expert or two experts to argue to a layperson as to why that may or may not be an explosion, and that simply isn't here. And Mr. Sale himself, that's not the conclusion he drew early on in the course of the litigation. He said, well, an explosion could have caused this.
He never opined that an explosion did cause this, did he?
That's correct, he did not. I think he was trying to help Art, who's a customer. He gave a very definitive position early on that it was defective welds, a defect in the weld itself that he did not characterize as an explosion at the time. He later said it could have. And whether or not
some other company was actually responsible for the welding, is that correct?
Yes, there was a third party that did the welds. It was not Mr.
Something.
Sale's company.
Yeah.
And whether Mr. Sale is an expert or a layperson, the testimony could have is speculation, and it wouldn't come in under either of those scenarios. And so there simply isn't any evidence from which a jury could conclude that an explosion caused this failure. I want to move on to the negligence aspect of this, which Art's reply brief really did not address at all. These are contractual. This is a contractual relationship between Art and Ace, and somehow Art has gone outside of the contractual relationship to argue that, well, my client committed negligence when it did the post-loss testing. In our brief, we posed the question, well, where's the duty and where's the breach? And that wasn't answered in the reply brief. There's been no duty identified by Art for the tort of negligence. This is not a special relationship that the law recognizes like an innkeeper and a common carrier. That doesn't exist. Ace did not possess custody or control of the property. And in fact, the parties...
So your position is all tucks in under the contractual duties that existed between the parties.
Exactly. And the contractual relationship was such that after a loss, yes, Art had to cooperate. Ace had a right of subrogation. Had they pursued subrogation against the welder, that also would have benefited Art. They would have gotten their deductible back. So it actually would have benefited both parties. In doing this testing for that purpose and in acknowledging that things can happen when you do testing, there was a protocol that said we're going to do destructive testing, and Art signed the protocol. It's hard to find a duty in negligence or a breach in negligence when contracting parties actually work through under their contract how they're going to perform.
What about its argument that it would not have removed all the refractory lining, that it just would have repaired it?
Right, so that's contradicted by Mr. Sale again, who said early on, before the testing was started, that all of the refractory was going to have to be replaced.
But it's summary judgment, so we have to view everything in the light most favorable to them.
Yes, but I mean his testimony was that the refractory would have to be replaced because he couldn't give a warranty the way it was from the damage. It's acknowledged that the explosion, it was acknowledged that the failure did not damage all of the refractory, but it would all have to be replaced in order to clean out and extract the damaged property. He said that early on. But that gets back to the breach. I mean, even assuming that that could be the case, that there's a fact issue on that, there is no duty and there is no breach. There had a protocol that there would be destructive testing. So how could ACE breach a duty that would give rise to this injury when ART agreed to allow for the destructive testing that was going to remove more of the refractory? I think those are the two main issues, which are the causation issue and that there cannot be duty in a negligence context. So unless the court has any further questions, we ask for affirmance.
Mm-hmm. Thank you very much, counsel. The case is taken under advisement. Our final case for argument today is Pierce against Vanahill. Mr. Rayfield.
Thank you, Your Honor. May it please the court, Mike Rayfield for the appellant. No one has disputed, not the state courts, not the district court, and not the government on appeal, that if Pierce's lawyer had objected to the state's drumbeat testimony, the objection would have been sustained under longstanding Indiana law. So there are just really two questions to ask about why counsel didn't object. One is whether she knew what the drumbeat rule was, and two, did she decline to object based on some kind of sensible strategy? Our position is that the answer to both questions is no, and either one of those answers independently satisfies the first prong of Strickland. So first, did Pierce's counsel know the drumbeat rule? And we need to be, and at Pierce's post-conviction hearing, his lawyer was asked point blank if, quote, drumbeat testimony, repeating the victim's story over and over again before she testifies, sounds like a familiar basis for an objection to you.
So I read that passage, and every time I read it, I feel that it's hopelessly ambiguous. You're right. Counsel actually asked her twice. Were you aware that you had this drumbeat testimony? Are you familiar with that? And at that point, there's just a request for clarification. As what? I'm sorry. So I can't get anything out of that. And then the questioner defines drumbeat testimony and says, does that sound like a familiar basis for an objection to you? And once again, you don't actually get a square answer. What you get is, no, that's not one I would have made for this. No. So I don't see her saying that's not one I'm familiar with. She says that's not one I would have made. And so the next question in my mind is, why wouldn't you have made it? Because you never heard of it? Because you think it's not appropriate for this situation? You know, didn't fit in with your trial strategy? You know, other things. And so then I say to myself, well, you know, here you have this ambiguous exchange. And we are not the first or even the second or third decision maker here. This is habeas. And so we owe all these layers of deference under AEDPA. So why is the Indiana Court of Appeals crazy to read this the way I'm suggesting perhaps you could, as just, I wouldn't have made that objection, not I've never heard of it?
Well, I think if you think there's ambiguity in the answer, then I think it's cleared up pretty well during Newland's cross-examination. And if you look at pages 913 to 914 of the appendix, when the state's lawyer asks her again about failing to object to repetitious testimony, Newland responds by talking about why she didn't make an asked and answered objection. And the reason for that is that she's focused on admissibility, on repetition, not on sequencing.
But you have to show by clear and convincing evidence, which as you know is a high standard, that the state court got it wrong. How, without an express admission from her that she wasn't aware of this evidentiary rule in Indiana, how can you get around the presumption and establish clear and convincing evidence? Because even what you're arguing now doesn't directly address the question of, did she know about this rule in the first place?
Right, so a couple things on that. First, the framing of the question was, are you familiar with the drumbeat rule? She answers no, but then I agree, she then goes on to arguably qualify that.
Well,
but I think the other...
she doesn't say no to are you familiar with it. She says, as what? I'm sorry.
No, but then the next question is, sorry, let me just.
Does that sound like a familiar basis for an objection to you? It wasn't, I mean, he asked a different question.
And then she says, no, that's not one I would have made, whatever the I would have made part.
So it's the basis for an objection, not, if he had followed up with, well, are you familiar with this? It might be a different story, but that's not the question that was followed up on.
Fair enough, Your Honor. And so let me just point to a couple other things. One is that she was asked about several different objections before she was asked about the drumbeat objection. Hearsay, why she didn't object to the state's presentation of a social worker on child molestation victims generally. And each time she gives an explanation, which is exactly what you would have expected her to do if she understands the drumbeat rule.
But that's not the question she was asked.
I'm sorry.
That's not the question. She's asked a different question here about the drumbeat. Are you aware of the possibility of objecting to the testimony as drumbeat? And then she says, as what? I'm sorry. And the lawyer asked a different question. Again, about, does that sound like a familiar basis for an objection to you?
Right. So was it familiar to her that she could object on the basis that there was all this testimony before the victim testified?
And she said, that's not one I would have made for this, no. And I agree with what Judge Wood said. That seems very ambiguous, and I don't know how you meet clear and convincing with ambiguity.
So I think you can look at what she said when she's asked about a follow-up question on cross. You can look at how she responds to the other objections where she actually provides an explanation. But here's the bottom line: what she certainly doesn't do is offer a strategy for failing to object. She doesn't offer any explanation at all. And that sort of brings me to the second point, which is that there was no sensible strategy for her failure to object.
So can I ask you, I mean, you mentioned briefly a minute ago sequencing, and I just want to make sure I have your argument straight in my mind. It's not that these other witnesses couldn't come in, but with the sequencing, if JW had gone first and there had been that, and then these various other people had come in, there wouldn't have been this building up of her credibility over the course of a bunch of adults, very flattering language about adults, a bunch of adults all saying the same thing, and then JW coming in and just tying it up like a bow. If JW had gone first, that's your argument, right? That
exactly.
She just blew it on the sequencing.
She blew it on the sequencing, and it's important to keep in mind that that's not just like a subtle thing. It's important to keep in mind that Indiana courts consider this objection to be so critical that it's reversible error for a trial court to deny it, precisely because it results in delayed cross-examination and, in the words of one Indiana appellate court, quote, overcomes the defendant's presumption of innocence. And here, I think the state court's error is pretty straightforward. It correctly found that Newland's general strategy was to argue that JW wasn't credible because her account of Pierce's conduct changed over time. But then the court found that a drumbeat testimony would have undermined that strategy because it would have made the adult testimony inadmissible, and it would have forced Newland to attack JW's credibility in isolation, words of the state court. And that's simply not how the drumbeat rule works.
But how is that a Strickland constitutional violation? The
Well,
court's interpretation of Indiana state evidentiary law, maybe that's wrong, but that can't be the basis for a constitutional violation of clearly recognized Supreme Court law.
Well, it removes the state court's it eliminates the state court's rationale for why her performance was not deficient under Strickland. If you don't have that, if you don't have
How can we simply eliminate the state court's rationale? It is what it is.
I'm sorry, I don't mean eliminate. I mean the way the rule works refutes the state court's rationale. The rationale doesn't make sense.
So you're now, yeah, I'm getting more worried. I wasn't worried earlier, but it now distinctly sounds like you're saying the Indiana court just didn't understand how Indiana law works, and that led it to an error in this case. I don't see how we can say anything like that.
I think
we're supposed to assume that they understand exactly how state law works. Only federal law matters.
I mean, I think it's interesting to look at Judge Bailey's dissent in the Indiana appellate court, where he disagrees with the state court and says, you know, all this would have done was change the chronology. And if you take that rationale out, if you say that rationale was unreasonable, then there's really no basis for the state court to say this was a strategic decision, because it's not, because the failure to make a drumbeat objection couldn't possibly have undermined the strategy if the objection had been presented properly. So I'll reserve the remainder of my time, if that's okay with the court.
Certainly. Ms. Templeton.
May it please the court. The state court reasonably determined that trial counsel did not perform deficiently. And a couple of points. This court, of course, cannot determine that the Indiana State Court applied Indiana state law incorrectly, And to that extent, it is the dissent that got Indiana state law wrong. In Stone itself, which is the case Pierce relies on for the drumbeat repetition testimony, like the progenitor of this line of objection in Indiana, the adults testified after the victim. It is drumbeat repetition when an adult lends their credibility to the victim's testimony, no matter when in sequence that happens. And there's at least one other Indiana court that has found reversible error when the adults testified after the child victim did. So an objection here would not have simply reordered the testimony of the witnesses, but it would have limited the specific testimony to demonstrate the inconsistencies in JW's stories through the various adults she reported this to. The adults still would have been permitted to testify that JW disclosed molest to them, but without the context of what she actually said. And so at that point, trial counsel would have been unable, or would have been less able, I guess, to argue to the jury that JW lied to her grandfather, she lied to the nurse, she lied to her mother, she lied to the Comfort House, which was the forensic interviewer, and she lied to the jury itself.
So can I ask you, just to be clear, you are disputing, I take it, your opponent's contention that had counsel understood what this drumbeat objection is and had made it, that it necessarily would have been granted. That the drumbeat testimony would have kept out.
I think if she had made that objection, it would have been successful, and it wouldn't have the point I was trying to make, Your Honor, is that it wouldn't have simply reordered the witnesses.
So it just you think it would have kept them out?
Yes, okay. I think it would have kept the specific statements.
And it would have been a good objection under Indiana law. So
yeah.
Counsel walked away, apparently for no strategic reason, from an objection that would have kept damaging testimony about his client out of the court.
I disagree that it was for no strategic reason, Your Honor. Here, because counsel permitted this testimony to be admitted, what the jury heard over and over again before JW testified was that JW told different stories, that JW lied during her first forensic interview, that JW's own mother thought that she lied, and that is entirely consistent with counsel's overall strategy to establish that JW was a liar.
It seemed like part of the strategy was also to bring out the escalating nature of the lies.
Yes.
Which you're saying if the drumbeat objection had been made and sustained, that she couldn't have brought that in.
Correct. And the state court reasonably determined that what counsel wanted to do was ensure that the jury heard all of these different versions. And counsel had deposed all of these witnesses ahead of trial. She knew what they were going to say. She knew what was going to come in. And she could make a reasonable strategic decision at that point about what parts of their testimony she wanted in and how that fit within her overall strategy. It is not sufficient to find reversible error that another trial attorney could have come to a different conclusion. It was still reasonable for the state court to determine that this attorney did not perform deficiently. There are no other questions, Your Honors?
So the state court said nothing about the prejudice half of the Strickland inquiry. So if we were to disagree with you on the performance, there's still prejudice out there.
Correct, yes.
Go back to their own.
And here, I think what that prejudice inquiry would look like would be comparing the trial if just J.W. had testified. And J.W. acknowledged these inconsistencies in her statements on cross-examination. She acknowledged that she lied during her first forensic interview. She acknowledged that she told her grandfather that Pierce had only molested her 4 times the first time she reported it. She acknowledged, she said she was asleep instead of being awake. She acknowledged all of the discrepancies. And so the jury would have been left with the same information to evaluate J.W.'s credibility, and so there's no reasonable probability of a different outcome.
Okay, thank you.
Thank you.
Mr. Rayfield, anything further?
So if you read Modestit, it's clearly talking about, the Indiana Supreme Court is clearly talking about sequencing. It's talking about how this tactic causes delayed cross-examination. It says immediate cross-examination is the most effective and delayed cross-examination is least effective. Prior to putting the victim on the stand, the victim's veracity had been in essence vouchsafed. So I just disagree with the government's reading of state law, but the point is that if you remove that, if the state law rationale makes no sense, then there's no strategy to back up Newland's decision. Now, as for Your Honor's question about the escalating testimony, that could have Newland could have elicited that testimony from J.W. herself. If J.W. had testified first, she could have asked her, "What did you tell your grandfather and when? What did you tell your father and when?"
Thank you, counsel. Mr. Rayfield, the court appreciates your willingness to accept the appointment and your assistance to the court as well as your client. The case is taken under advisement and the court will be in recess.